This week, on the Trump Corruption World Tour, we're diving into how Trump and his administration has turned our justice system into a tool for punishing dissent. Through a series of executive orders that cannot be legally justified, Trump has targeted law firms that represented his opponents or challenged his policies, suspending security clearances, canceling contracts, and barring firms from federal work. These orders were issued to intimidate lawyers for doing their jobs and to dismantle diversity and public service programs that don't fit the administration's bigoted and offensive ideology. Firms like Paul Weiss, Skadden, and Milbank were strong-armed into signing so-called settlements worth tens of millions of dollars in pro bono commitments and forced to abandon their diversity programs. Others, like Jenner and Block, Wilmer Hale, Perkins Coie, refused. They refused and took the administration to court, and they won. Legal experts have been warning that these pro bono commitments may violate the Hobbs Act, which prohibits officials from obtaining something of value through threats of government action. But the goal was never to reform the system anyway. So, like all the other petty Trump ventures, it was always just retaliation. This was an attempt to scare lawyers out of defending anyone that the president considers an enemy, and an attack on the foundation of justice and their continued assault on the First Amendment. When the government gets to decide who can represent whom, the rule of law becomes a political weapon. Our ability to retain counsel and challenge authority, even the authority of the government, is our last line of defense against an administration that is counting on intimidation tactics to discourage us. Every American should see this for exactly what it is: a direct threat to democracy and the freedom that protects all of us.